Good evening, ladies and gentlemen. Good evening. I'm your host, Kiana Canada. Welcome to the Kiana Canada Show. Let me just adjust some lighting because in this room, the lighting is not that bad. Excuse me, the lighting is horrible. And I had to go and get a lamp. And so let me see if I can adjust it. Just a moment. Is that? Let's see. Maybe just a moment. Do you see what I have to go through? Is that's horrible. Just a moment, ladies and gentlemen. Uh, okay, I think that is just going to have to do. That's just going to have to do, ladies and gentlemen. Today, I am coming on here to talk about a very serious issue. And before I get into today's topic, don't forget to like, share, and subscribe to this channel. Remember that your likes and your shares, what it does is it pushes videos like this up in the algorithm. It tells the algorithm that videos like this are important. But we must be reminded that just because videos like this are not pushed up in the algorithm, that is not an indication that videos like this are not important. And so this is going to be there's going to be, I'm going to have to be careful about what I say in this video. As you know, I am an American and I have filed an international protection claim against the United States of America. And in 2022, I began to learn that the United States and the Republic of Ireland were colluding with each other and pushing Americans out of the international protection process and doing so against the 1951 Convention and other international instruments. And when I discovered this, what I thought was happening was that there was coercive repatriation. So we know that voluntary repatriation is where a person decides to leave a country on their own and without any coercion or force. And I discovered that this coercive repatriation was connected to authority figures collaborating with individuals, so persons, asylum seekers within the international community so these asylum seekers would assist authorities in pushing specific persons out of the international protection process, specifically American persons. And so, ladies and gentlemen, when I wrote about that in The Jurist, what happened was that the intelligence agencies swooped in and oppressed me and intimidated me. And ladies and gentlemen, we're going to be talking about a lot in this video. And so everything that we talk about is going to be under the honest comment doctrine, and it's going to be in the public's interest. And so before I get into that, I want to continue by saying that the authority figures, what they did was they swooped in and began to intimidate me and oppress me more. And then I learned that this behavior, this conduct was transnational repression. And so when I began to speak out and say, hey, this is transnational repression, nobody knew what I was talking about. The human rights were feigning to not know what I was talking about. The international community, such as human rights organizations in the Republic of Ireland, were pretending that they didn't know what transnational repression was, and many other organizations. And what this did was this led me to believe that this was an ongoing practice that the global north was engaging in rather covertly and implicitly. And actually, I think blaming it solely on the global south. And if you've been watching my commentary, you know that I speak from the gut, right? Or speak from the hip, whatever the saying goes. I do that. And I'm very candid in the things that I talk about. And so if I support a position, I will say I support a position. If I don't support a position, I will not support it. And I will tell you why I don't support it. But there's something happening at my university that I think that we need to talk about. And what's happening at my university is in the public's interest. And I'm going to cite why I believe it's in the public's interest. So whenever, and this is going to structure this video. So whenever a matter is such to affect a large number of people so that they may be legitimately interested in or concerned at what is going on or what may happen to them or to others, then it is a matter of public interest on which everyone is entitled to make a fair comment. And so, ladies and gentlemen, this video is in the public's interest. The people that I'm talking about in this video is within the public's interest, and the people are able to make a fair comment on it. And I'm going to be supporting my arguments with law and not only am I going to be supporting it with law, but I'm going to be supporting it with this book here as well. And so this is the Essential Law for Journalists. It's the 26th edition, and it's up to date so that we know that the law that I'm citing is not, antiquated. But what is deeply concerning to me, ladies and gentlemen, is that, let me get it. What is deeply concerning to me, ladies and gentlemen, is that I have been a respectful student here at Queen's University. I've engaged in respectful debates. I've looked up to majority of my professors here at Queen's University. I have actually been very vocal about seeing my professors as mentors. I'll link those videos in the description of this particular live stream. There is like a podcast that I did about Dr. Yassine Brunger, saying that I looked at her as someone who is captivating and very interesting, and that I like her teaching style. And I said the same thing about Dr. Oloade. Oloady. And so, and I'll link that video in the description, or I think it's a podcast that I did, but I'll link that in the description as well. I haven't spoken out negatively about any professor here at Queen's University. As I stated in the video before that I published yesterday, that it was privileged to be studying under their tutelage, and that I appreciated that their guidance and their direction. And so, ladies and gentlemen, it is deeply concerning to me that a professor here at Queen's University, and again, this video is in the public's interest, and I'm giving my fair comment. This falls under the fair comment doctrine. And just so we can make sure, so you don't think, oh, well, Kiana, well, you're making things up as you go. So this is how I'm going to be structuring the comments that I made in this video, or excuse me, the comments that I made regarding a specific professor here at Queen's University, and why I believe it is an honest opinion and that it is not malice. So the requirement of the honest opinion defense, of all of which must be met, are the published comment must be the honestly held opinion of the person making it. That's one. Two, be recognizable to the reader, viewer, or listener as opinion rather than as a factual allegation. Be based on a provably true fact or privileged material. So media organizations relying on this, or even YouTubers relying on the honest opinion defense, should be prepared to run another defense such as truth, absolute privilege, or qualified privilege in tandem. Explicitly or implicitly indicate, at least in general terms, that the fact or information on which it is based. Now, ladies and gentlemen, this gets me to the crux of this video. I was pulled into another meeting with the head of school, and the head of school said that a professor here at the university has launched an allegation against me. And ladies and gentlemen, we're going to go into that allegation, and I'm going to read you the email, the entire email that I wrote, and then let you judge for yourself if what I said was out of context, if you think that what I said was malicious. And I'm telling you beforehand that the email was not sent in malice. And how I know that this email was not sent in malice is because I've never met this professor before. I've never met him. I've never had a sit down meeting with him. I've never seen him before. So I can't say anything negative about him. And the information that I cited in the email was based on the article that he wrote. Now, this professor, his name is Dr. Luke Moffett. And when it comes to dissertations, ladies and gentlemen, what normally happens, in my understanding, is that you, as a student, you are able to request a dissertation supervisor, but that does not necessarily mean that that supervisor will be that you'll be given that supervisor. And so, interestingly, I requested a different supervisor because I wanted to be mentored by somebody who their research aligned more with the dissertation that I was going to write. And so, with my stating that, ladies and gentlemen, please understand that, to reiterate, I've never met Dr. Moffett. I've never seen him before. So I don't have anything negative to say about him. Actually, to tell you the truth, quiet is kept. I think he does a phenomenal job in transitional justice. And we know that to be true is because I cite him all the time in my pieces at the university. So I cited him in my transitional justice class. I've actually cited him in my restorative justice class because I think that he is a phenomenal scholar when it comes to transitional justice. But when it comes to reparations and when it comes to being transnational repression, I think that there is a conflict of interest. And so the email that I submitted to, turning this on just a moment, we're going to get into the email that I submitted to the School of Law, which I felt was in. I really felt that the email was professionally written and that it was going to be received well. And I did not, ladies and gentlemen, to reiterate, there was nothing in this email that I felt was malicious, nor did I intend to libel or slander the professor. Now, keep in mind that when I sent this email, ladies and gentlemen, that I'm about to read to you, this was an inter-office communication. So I didn't publish this online, nor did I publish it anywhere. This was seeking guidance from the university. And the only reason why I'm publishing it now, the only reason, ladies and gentlemen, as to why I'm publishing it now is because this professor is moving against me in a way that is about to impact the legacy that I want to create. And so this is the email, ladies and gentlemen, that I sent to the School of Law. And I'm going to read it and I'm going to base it on the facts that I have, that I was going off of. I'm bringing it up. I'm sorry that it's taking some time. Now, please keep in mind that I'm sharing this email because it is in the public's interest. I'm sharing it because it's in the public's interest. It's in students' interest. It's in academics' interest. The fact that I am being called into the office and that my livelihood as a student here is being placed in jeopardy because I submitted this email and that I am being written up for submitting this email is highly disturbing. And ladies and gentlemen, this is what I said, and I'm reading it in full. I said, "Dear Claire, I hope your day is going well. I am writing to respectfully decline the assignment of Dr. Luke Moffett as my dissertation supervisor due to a conflict of interest. As you are aware, my dissertation focuses on transnational repression, specifically examining the role of states in the global north and the racial dimensions of oppression. I am also concerned that Dr. Moffett will not provide the best supervision for this work, and that he may not treat me impartially." The key word there, ladies and gentlemen, is may. For instance, Dr. Luke Moffett published the following: "Slave reparations. There's little legal basis to make companies pay for historic actions." Further, I believe Dr. Moffett's perspective on race in the United States contributed to the low mark he gave me on my assessment. Further, his perspective on reparations excuse me, his perspective on reparations on descendants of slaves and race relations in the United States makes me extremely uncomfortable. It is also likely, the key word there, likely, to affect the overall supervision of my dissertation. I greatly value the guidance and support provided by the School of Law and would be grateful if we could explore the possibility of assigning an alternative supervisor whose academic interest aligns more closely with the themes I'm addressing in my research. As a final note, please be aware that someone has been sending, interpreting, excuse me, sending, intercepting, and altering the emails I send from this account. If you receive an email on this issue prior to today, please let me know. Thank you for your understanding, and I look forward to your guidance in finding a suitable supervisor. Now, ladies and gentlemen, can you tell me, like, how was that malicious? I didn't say anything malicious about the professor. So let's go to the part that I think that they are interpreting, that they believe could be malicious, because I said, I'm also concerned that Dr. Moffett will not provide the best supervision for the work that I want to put out into the universe. But that's just my honest comment. And if we are calling me into the office for making that statement there, then they have to call all other students into the office, because I've not been the only student at this university who has not been satisfied with their supervisor. So if you're calling me into the office and you're writing me up for that statement there, that I'm also concerned that Dr. Luke Moffett would not provide the best supervision for my work, then you have to call the entire campus into the office, because I've spoken to, like, at least, I want to say 10 students here at the university who said, well, I sent an email to uh, A, B, and C, and I told them that I don't think that this supervisor is the best supervisor for me. So let's say, for instance, that they're not focusing on that statement, right? In that opinion that I submitted, but they're focusing on this, that he may not treat me impartially. Well, the key word there, ladies and gentlemen, is may. I didn't say that he was not going to treat me impartially. I said that he may not treat me impartially. And then if they are resting their case solely on the article, well, ladies and gentlemen, let's go to the article. And I'm not sure if they're going to let me publish this article, so I'm just going to read it. So I'm going to read the articles. So I'm not really certain if they're going to allow me to publish it, but it states, and this was written by Dr. Luke Moffett in 2020, June 19th. And he wrote it in The Conversation, and it says, slavery reparations. There's little legal basis to make companies pay for historic actions. Two major British businesses have said that they will make undisclosed payments to Black and minority ethnic groups to atone for their past owners' involvement in the transatlantic slave trade. Pub group Green King and insurance broker Lloyd of London have both apologized for what they respectfully call inexcusable actions and indefensible wrongdoing. This comes as High Commissioner for Human Rights Michelle Blanchette has called on countries to convert their past involvement in colonialism and slavery to make reparations for those still affected. It also follows the University of Glasgow's announcement last year of a 20 million pound, I think it's in pounds, a 20 million pound fund to make amends for benefiting from the transatlantic slave trade. So, why is the legal position when it comes to slavery reparations, and where is corporate liability likely to go from there? So, this is, he's writing the legal case. Reparations for slavery has been demanded for centuries for African American, British Caribbean, and Caribbean people. Now I'm going to stop right there. I'm African American, so he is bringing my people into this argument. Let's continue. In 2021, the UN Urban World Conference Against Racism recommended, let me see if I can, let's see. Okay, so reparations for slavery has been demanded for centuries for African American, British Caribbean, and Caribbean people. So to reiterate, he has brought my people into this article. In 2021, the UN Urban World Conference Against Racism recommended reparations for racism, but the momentum was lost as the debates were quickly overtaken by this event. Since then, research has uncovered numerous individuals and companies that have benefited from slavery in the past. Besides Greene King and Lloyd of London's, the UK banks HSBC, Barclays, and Royal Bank of Scotland are all known to have similar links. In the US, the list has included JP Morgan, Bank of America, and the clothing retailers Brooks Brothers. Now he's bringing my country in it. So it's not only African Americans, but then there is that link, the country link as well. I'm from the United States of America. None have paid reparations, although, for example, JP Morgan set up a scholarship fund and apologized for the involvement of its predecessor companies in slavery in 2005. A legal case seeking reparations from the bank and other insurance companies then collapsed in 2006. The payments by Greene King and Lloyd of London's are not reparations in the legal sense either. In the past few decades, reparations have become a key part of international law, ensuring an effective remedy for those who suffer violations. Reparations are intended to vindicate victims' right to reaffirm their dignity as human beings and to reproach those responsible for their wrongdoing. Reparations are not so much about money, though money can certainly give victims new opportunities, as confronting those responsible with their wrongdoing and getting them to recognize the value of their victims as human beings. Let's continue. In the past, and ladies and gentlemen, I just want to make sure that we're still good and that this is showing up. So let me see. Oh, ladies and gentlemen, I think we're good. So in the past 2 decades, there have been increasing reparations paid by corporations for their involvement in historic violations. These have mainly concerned, of course, the Holocaust, such as the French and Dutch train operators that transported Jews to concentration camps, Swiss banks that withheld Jewish accounts, and various German corporations, including Bayer and Volkswagen, that benefited from forced labor during the Second World War. And so he says, yet these successful cases occurred when survivors were still alive and there was sufficient evidence to find a responsible actor to make reparations. Time time makes legal claims go stale. All of the victims of the transatlantic slave trade are now long dead. And that's, ladies and gentlemen, that's not true. Our ancestors may be not here anymore, but we're still victims of that painful legacy because we're still dealing with that legacy today. That legacy has not gone away. And so he goes on to say that so it's difficult to legally speak of a direct victim who would have standing to bring a claim. Ladies and gentlemen, this is, of course, his opinion, because when we look at the literature specifically states that even if your family member passes away, right? And so essentially that's, our ancestors are like our family members, of course. Even if they passed away, we're still victims of that harm. We're still victims of that harm. Indeed, if you really want to be honest, there are still families today that are receiving legal judgments because something happened to their family. Either their family was wrongfully imprisoned and died in prison. There was a person who let's say, for instance, ladies and gentlemen, if we are to accept his argument that he makes here, then families of police violence can never ever file a claim in civil court because the victim is no longer here. But we know that's not true, right? Because whenever a police officer, whenever there's an extrajudicial execution and someone dies because of that, well, that victim is not here to file a lawsuit. Only their family members can file a lawsuit for that wrongful death. And so, ladies and gentlemen, the argument that he makes, if this are his words, now this is published on his page on QUB. Today, I asked the head of school if this was his art, if this was his paper. She didn't decline. She didn't say that this wasn't his work. And I told her, if this is not his work and it's fake news, let me know, and I'll retract what I'm saying. But ladies and gentlemen, what's deeply concerning, like I said, is that when victims are no longer here, their families are filing claims for that wrongful death and for that injustice and that harm that happened in the past. And so if we follow Dr. Moffett's argument, then that means that victims of injustice, when their family member has been unalived by law enforcement, that they can never claim in civil court. Let's move on. Unless new evidence emerges clearly implicating a corporation for historically profiting from slavery, it is unlikely that there will be a basis for a legal case to proceed. Now, ladies and gentlemen, I didn't bring any argument in my email about a corporation, and not one argument. And realistically, ladies and gentlemen, if we follow the money, if we go back in time and we go back to money being passed down through generation and generation and generation, I'm quite certain that we can identify corporations that have condoned or participated in the transatlantic slave trade that are still erected today. Now, keep in mind, to reiterate, in my email that I just read to you, I didn't make any claim about a corporation. I'm talking about this piece, the thought process in this piece, what I believe to be his ideology on this particular issue. Let's continue. There has been more general reparation claims under domestic law for colonialism, such as the Mama settlement from the British government in 2013, and this year a case which resulted in compensation being awarded to Holland for the unalivement of Indonesian civilians under Dutch colonial rule. Let's continue. But these claims were against states, which are more permanent entities than corporations and have different international legal obligations. The 2011 UN Guiding Principles on Business and Human Rights speaks of corporations respecting human rights by avoiding infringing them and to address adverse human rights impacts. States, on the other hand, have a clear obligation to offer reparations in such situations. Let's continue. Now, he does concede that states have a obligation to uh, offer reparations, but he doesn't say what those situations are, right? Let's continue. Now, he does say this. He says, reparations can be framed in other ways if legal avenues are closed. The Caribbean community has for years been calling for collective and moral reparations from the European former colonial powers for the continuing harm felt by its 15 member states from the transatlantic slave trade, colonialism, and indigenous unalivement there. The Group 10-point plan focuses on collective measures in the form of an apology, repatriations to Africa, educational and research opportunities to build cultural institutions, psychological rehabilitation, and debt cancellation. However, no European power has made any efforts to meet the demands, including UK, which refuses to apologize. Now, ladies and gentlemen, these are his words. And if they're not his words, then somebody needs to come out and tell me that these aren't his words, because this is published on his page. At the same time, the reparations announced by Lloyd and Green King do not perfectly correspond to victim-centered reparations as understood under international human rights law. There is a risk that just paying money and apologizing for past wrongdoing can absolve oneself from the past. Such payments risk being seen as self-serving public relations exercise rather than a genuine attempt to atone and to prevent the wrongs from happening again. Instead, a key legal requirement of international reparations is to ensure that the victims participate so that compensation can be as effective as possible and not simply charity. But reparations, financial reparations, are not charity. It's an atonement for a past wrong. So charity is you're giving somebody something for free, right? You're giving somebody, you're donating something to someone, you're giving it to someone for free. And if we want to get technical about it, let's go to what we're going to define charity. So charity is, the second definition is the voluntary giving of help, typically in the form of money. Reparations is not a voluntary giving of help. There was a debt that's owed to descendants of slaves for that labor, that free labor that happened in the past, that our ancestors didn't. And ladies and gentlemen, this is not an incitement to violence. This is not an incitement to hate. We're talking about the facts here. I would assume that this is respectful debate. Our ancestors did not get paid for that free labor. And if they refused to engage in labor, they were whipped, they were lynched. So someone tell me how a country that is giving reparations for a historical wrong, how that is voluntary. It's a debt that is owed. Let's continue. This is also to avoid replicating power dynamics of benefactor and beneficiary so that the victims are treated as right holders with agency. How far can such claims making over the past go? Perhaps in dealing with slavery and its pervading effects today, we need to revisit the 2001 Durban Conference finding. This would involve having a broader conversation about the continuing consequences of historical injustice and how we can identify and remedy the continuing effects. Reparations cannot provide a complete solution. Yes, it can. Because to address this argument, ladies and gentlemen, and do you see now why I say that there is a conflict of interest? Well, I honestly believe that. Yes, reparations can provide a complete solution because what it does is it's equity, right? It brings Black people up. And we understand that in many countries, especially the United States of America, Black people are below when it comes to there's like a large wealth gap between the dominant society and Black people. And it has to do with that legacy of the transatlantic slave trade. That just didn't come out of nowhere, that wealth gap. There's been generations and generations and generations. And when Black communities attempted to build themselves up, ladies and gentlemen, when we attempted to during the period of Reconstruction, when we attempted to build ourselves up and build our own communities and to have something for ourselves, we had the dominant society coming in and tearing it all down. Tell me today, if a person comes into a community and they tear something down, they they break into a car, or excuse me, they vandalize a car, they vandalize a house, etc. Would the court not make them pay restitution for their actions? Let's really think about it. Say, for instance, someone causes damage, considerable damage. Is the court not going to order that person to pay restitution, or there be some civil penalty? When Dr. Moffett says that reparations cannot provide a complete solution, he is replacing the voices of descendants of slaves with his own. And he is speaking for us. And we have come out and said that we believe that reparations can be a complete solution to that historical wrong. Is that history always going to be there? Of course. No one is disputing that. No one is denying that. But if you speak to descendants of slaves, 99.9% is going to tell you that they believe that reparations is a solution. Now you're going to have this small percentage that is going to say that that's not solution, but they don't speak for the majority. The majority has already spoken. The majority says that we are the majority and we feel that that is the right solution. And we shouldn't be made to feel guilty and we shouldn't be reprimanded because we feel that way. Let me continue. He goes on to say that no amount of money, memorial, or apology can fully remedy the past. Nonetheless, there are a way of acknowledging wrongdoing and victimhood while seeking justice and transformation so that such violations do not occur. Well, Dr. Moffett, that's your opinion, but you're not, respectfully, a descendant of slaves. And your ancestors has not been, well, I don't know, but if you want to have a conversation about this, I'm open to having a conversation with you about this. But my ancestors were in the transatlantic slave trade. And my mom used to tell me stories about her picking cotton. Her being made to pick cotton. She used to tell us stories all the time, and when we were small, we didn't believe it because we were just children, and we couldn't fathom how, in a world where we didn't have to do that, that our parents had to do it. My grandmother used to tell me stories about her having to pick cotton. So there was a sentence in the article, ladies and gentlemen. So again, my commentary, not my commentary, but my email to the head of school was not in malice. As you can see, I pointed out clearly that there is a conflict of interest here. And the fact that Dr. Moffett, I guess allegedly, I'm not sure, they didn't tell me, but they said that he made the complaint against me. That he made a complaint against me because I sent this email. But ladies and gentlemen, did you read you saw the article that I read, right? And again, my opinion is not out of context. Remember, this comes as UN High Commissioner for Human Rights, Michelle Blanchette, has called on countries to confront their past involvement in colonialism and slavery. So, ladies and gentlemen, this was in 2020 when he wrote that article. And I'm going to go, so that article that he wrote was in June 2020. And ladies and gentlemen, this is an article that was published in The Guardian. I'm just going to see if we're still good and if that article is showing up. Let me see if these. I'm going to see if they're going to let me share the article in The Guardian again. Okay, so they're not allowing me to share that article. So what I'm going to do right now is I'm going to take a screenshot of the article, and then I'll read from the article, ladies and gentlemen. That way, like, I can keep evidence, like, this is what I see online, and this was written by Who wrote this? Okay, so I won't share this article because I don't see like a name on it. So I can't tie it to a person. Let's see. Okay, so maybe I can share this article. Maybe it'll let me share this one. It's not allowing me to share my screen, ladies and gentlemen, so let me try something else. Share. For some reason, it's not letting me share any articles, but it's let me go to this. Now, this was in the article, so if this is not an accurate, let's see. I'm gonna look up this number. Just a moment, ladies and gentlemen. See, I have to do my due diligence in this to make sure that we're not sharing fake stuff. Let's see, share my screen. Okay, it's for some reason it's letting me share my screen. We're wasting some time. So let me say this. Dr. Moffett, I did not it was never my intention to cause you malice or to be malicious against you. And we know that to be true because to reiterate, when I was in my first semester and even in the second semester, I cited your work multiple times because I saw that your work was powerful in transitional justice that I felt was illuminating and intellectual. And I'm very disappointed that you've come out against me and made this allegation because I wanted a supervisor that is more aligned to the dissertation that I want to write. Now, I will reiterate if you did not publish the article, um, there's an article on your page. I'm going to take a screenshot. It's on scholar.uk and it's also on your QUB page. And it's titled Slavery Reparations. There's little legal basis to make companies pay for historic actions. It's saying that you wrote that in 2020. If you didn't write that in 2020, then I apologize. But then we can't hold me responsible for that because remember that I don't know who wrote that article. But the article has your name on it. It says your name. It says your name. And it's on multiple pages. It's on your QUB. So let me go to that. I'm not sure if they're going to even let me, like, they're only letting me show. But anyway, the article is on your QUB page. So just a moment. Let me look for it. So this is not me slandering you. This is, if you didn't write this article, this is someone else that's slandering you, because you must remember, I don't have IT skills. So if you didn't write this article, then I think I'm the wrong person that you should be coming after for this. You know, I don't understand why you're coming after me, because I didn't publish this article. You did. So even on your QUB research output, and I'm going to take a screenshot of it. It's showing on your research output on QUB that you wrote the article. And just a moment, I'm going to take a screenshot. And the title is the same, Slavery Reparations. There's little legal basis to make companies pay for historic actions. This brings me to the legal part, ladies and gentlemen. So was the email that I sent to the School of Law wrong? The answer is no. And the law is supporting me here. So in British Chiropractic Association versus Singh, having classified the published remarks as factual assertions rather than the mere expression of opinion, EDJ stated that one is not permitted to seek shelter behind a defense of fair comment when the defamatory sting is one is not permitted to seek shelter behind a defense of fair comment when the defamatory sting is one of verifiable fact. Here, the allegations are plainly verifiable, and that is subject of the defense of justification, and an issue capable of resolution in the light of the evidence called is a matter of verifiable fact. Now, in my honest opinion, there is an article that is online. There is an article that is online and also in your research output. It's on Google Scholar and it's on your research output saying that you wrote this article. If you didn't write the article, I think what the correct approach to take would be to call me into the office and say, Kiana, where did you find that article? I didn't write it. And I would have been like, oh, well, I'm sorry. Like, this is online. And I'd taken a screenshot of it. But that's not what happened. I was called in the office and I was threatened with discipline because I cited that article, which is on your page. Now, let me continue by saying that that article is verifiable. Anybody can look up and find that article. And again, I'm not an IT person. I don't have IT skills. I'm not a hacker. So if they remove that article, that doesn't have anything to do with me, but I've taken a screenshot of it and it's on your research output and I have a copy of it. It was written in the conversation. So if you didn't write that, then this is a conversation that you need to have with the publication, and tell them to remove that article. Now, the law specifically states that you're saying that I libeled Dr. Moffett is the claim, but the law specifically says in a libel claim, the words used are material facts and they must therefore be set out verbatim in particulars of the claim, preferably in the form of a quotation. It is not enough to describe their substance, purport, or effect. So essentially, what you have to do is you have to quote the entire email that I sent, and you have to put it into context. You can't just take a little piece of it and then judge it from there. You have to judge it from the entire email. So I will read the email again. Dear Claire, I hope your day is going well. I am writing to respectfully decline the assignment of Dr. Luke Moffett as my dissertation supervisor due to a conflict of interest. As you are aware, my dissertation focuses on transnational repression, specifically examining the role of the states in the global north and the racial dimensions of oppression. I'm also concerned that Dr. Moffett will not provide the best supervision for this work and that he may not treat me impartially. Again, students are sending correspondence to the head of school and to the reception about supervisors that they believe will not provide the right supervision for their work. So, are all other students being called into the office and saying that their email is libelous? For instance, Dr. Moffett published the following, and so there's that article that I quoted. And then I said, I further believe Dr. Moffett's perspective on race in the United States may have, I said, contributed to the low mark he gave on my assessment. Well, I'm reading that article, and then in my assessment, ladies and gentlemen, I wrote about three women, a woman named Latoya, Breonna Taylor. I've also written about Sonia Massey, three women that lost their lives to law enforcement, that were extrajudicially executed by law enforcement. And in my piece, I said that these women had a right to life and how international law protects their right to life. And he didn't give me the mark that I felt that I should have received for that assignment. And in the piece, instead of evaluating the right to life and in the context of extrajudicial executions of Black women, he said that I should have written about war. When that wasn't the assessment topic. The assessment topic was, is the right to life, I think, viable or inviolable in international human rights law? That was the question. So how is we shoehorning war into that question? If students are permitted to write and give an opinion on this question and to provide, I guess, to choose a topic that they want to talk about, or to choose a topic that they would want to write about, then to be clear, let me say this. I am going to scratch what I just said, and I'll say this. If the School of Law wanted students to write about war, that should have been in the question. The question should have stated, does war violate the right to life? But that wasn't the question. The question was, is the right to life guaranteed in international human rights law? And my answer to that was yes. International human rights law does guarantee the right to life. People take the right to life away, not international human rights law. So let me go on with the email again. I said, further, I believe Dr. Moffett's perspective on race in the United States contributed to the low mark he gave me on my assessment. Further, his perspective on reparations, on descendants of slaves, and race relations in the United States makes me extremely uncomfortable. It is also likely to affect the overall supervision of my dissertation. Ladies and gentlemen, that's just my honest opinion. Just by reading that article that is published on his research output, it's not malicious, not at all. Again, the law says you have to read the entire email that I sent, not take a sentence in out of context. And so let's continue. I greatly value the guidance and support provided by the School of Law and would be grateful if we could explore the possibility of assigning an alternative supervisor whose academic interests align more closely with the themes I'm addressing in my research. As a final note, please be aware that someone has been sending, intercepting, and altering the emails I send from this account. If you receive an email on this issue prior to today, please let me know. Thank you for your understanding. I look forward to your guidance in finding a suitable supervisor. How, ladies and gentlemen, is that out of context? And how is that malicious? So, what does the law say? Let's go back to the law. Only recognizable comments, not facts. So, and of course, this is because they're saying that I libeled Dr. Moffett. We have to go to the law on this. So, a judge gave an example of an opinion protected by the fair comment defense, saying that if one accurately reports what some public man has done and then says such conduct is disgraceful, that is merely an expression of one's opinion, a comment of the person's conduct. But if one asserts that the man is guilty of disgraceful conduct without saying what that conduct was, one is making an allegation of fact for which the only defense are truth and privilege. So, ladies and gentlemen, what did I do? This is what I specifically stated. So, in the email, I said, for instance, Dr. Moffett published the following article. So I'm not taking anything out of context. I'm referencing that article and Dr. Moffett speaking on reparations. He mentioned African Americans in that article. So not only did he mention African Americans, he mentioned the United States. I'm from the United States. I'm African American. And he is giving his thoughts on whether or not my people deserve reparations. And somehow, because I say that I feel uncomfortable with his opinion on reparations, now I'm being made out to be the bad person. I just don't feel comfortable with if he truly published that article, and we have an opportunity to really discuss it like adults. If he didn't publish that article, then we can meet and he can say, Kiana, I didn't publish that article. And then that would give me the opportunity to apologize to Dr. Moffett and say, look, I'm sorry that I wrote this email. I thought you published that article because it's on your output. And I can retract my commentary or my statement. But ladies and gentlemen, they today in the meeting, she didn't say that he did not write the article. And I brought up the article several times in the meeting, and not once did she say, well, he didn't write that article. So going back to what I think that they are talking about, I'm also concerned that Dr. Moffett will not provide the best supervision for this work and that he may not treat me impartially. Look, he made a complaint against me for sending this email. How is that not demonstrating, improving what I'm saying? Further, I believe Dr. Moffett's perspective on race in the United States contributed to the low mark he gave me on my assessment. Ladies and gentlemen, that's my honest opinion. I honestly believe that. And the law supports me. So this is what the law says. The law does not require the truth of the comment to be proved. Comment may be responsible or irresponsible, informed or misinformed, but cannot be true or false. Defendants pleading honest opinion do not need to persuade the court to share their views, but they do need to satisfy it that the opinion on an established fact represents a view of an honest person could hold. Okay, so if you are a descendant of slave and you read that article that Dr. Luke Moffett published, and I'm only talking to descendants of slaves, and your family was in the slave trade, would you feel comfortable having a person like that as your supervisor when you're talking about the transatlantic slave trade in your dissertation? So there was a case, Silken versus Beaverbrook newspapers, and this was in 1958, but it's still relevant. It says the basis of our public life is that the crank and the enthusiast can say what he honestly believes just as much as a reasonable man or woman. It would be a sad day for freedom of speech. It would be it would be a sad day for freedom of speech in this country if a jury were to apply the test of whether it agrees with a comment instead of applying the true test of whether this opinion, however exaggerated, obstinate, or prejudiced, was honestly held. You can see, ladies and gentlemen, like this is just my honest comment. It's what I truly believe. And I didn't impute an improper motive to Dr. Luke Moffett. I read the article verbatim. Just a moment. What am I looking for? So as we can see, ladies and gentlemen, the law is supporting me on this. Like, I didn't libel this person. Just a moment, just to be sure while we're talking about it. Now, 21. Okay, just a moment. So there was a case, ladies and gentlemen, it's called Thornton versus Telegraph. And the judge held that that honest comment is not available as a defense to malicious falsehood. And of course, in this case, there is no malicious falsehood. This stage of the Thornton litigation involved an application by the defendants to amend the case and to rely on the defense akin to honest comment. According to the judge, the question posed by the proposed amendment was, is it the law that the words complained of cannot be regarded as false if they are comment which an honest person could express on the basis of the contents of a book which are identified? The judge noted that in defamation, where honest comment is raised, the defendant must prove that the words are comment based on correct facts, that the comment is one that an honest person could have made. So, reading that article that is on Dr. Moffett's uh, his research output, and again, right now, Dr. Moffett, I am welcoming you to have a meeting with me and for us to sit down and actually discuss this. Like, you're an academic, and if you and you're in the school of law, and you are supporting, or excuse me, you're in the school of law, and uh, you're part of the international human rights law program. So I would assume that by being part of this program that you are a proponent of free speech under Article 10. And I would welcome a meeting with you to sit down and have a conversation about this article. And I think the conversation would need to go something like this. If you did not publish this article, then you would say, Kiana, I think that article is fake news. I didn't publish it. And that would give me the opportunity to say, hey, I apologize that I have based my opinion around this article that is on your research output page. And I would show you where, well, I've taken a screenshot of it, and I could show you, okay, well, I've taken a screenshot of this. It's showing on your research output page, but you are claiming you didn't write it. And I think that that's how we would solve this problem. Okay, you said that you didn't write it, and I would apologize, and then there would be no problem, right? Because there is a mistake of fact there. But if you did write the article, then my opinion stands. And if you ask any descendant of slaves, because that is the similarly situated persons that you would need to ask in this situation, as to whether they would think that that your guidance in a piece that's talking about the transatlantic slave trade and transnational repression, whether there would be fairness there. Again, the comment is one that an honest person could have made. So the comment that I made in my email, you have to ask other descendants of slaves if they would have made the same comment. The latter criterion is objective criterion, but the defense can be defeated even if this criterion is met by proving malice. The effect of the objective criterion in defamation is that if a defendant draws a false inference of fact, then provided an honest person could be believed that inference to be true, the defendant is not liable. Let me read that again. The effect of the objective criterion in defamation is that if a defendant draws a false inference, a fact, so basically I'm inferring by reading that article that you don't believe that descendants of slaves should be given reparations. That's the inference that I'm making from that article. The defendant is not liable unless the claimant can prove that the defendant did not believe the inference to be true. Well, I believe it to be true because that article is on your Substack. That article is on your research output. And I'm being called into the office because I said I felt uncomfortable about it. So this makes it more true because you didn't attend the meeting and you didn't say, Kiana, I didn't write that article. You didn't call me into a meeting. You just reported me to the head of school because I said I felt uncomfortable with you as a supervisor. The effect of introducing the objective test into malicious falsehood would be the opposite. If a defendant draws a false inference of fact, then provided an honest person could have believed that the inference to be true, he is not liable, even if the claimant could prove that the defendant did not believe the inference to be true. So again, there are there's a dual part test here to the objective criterion that works in my favor. Well, the inference that I'm drawing, even if that inference is, the inference is false because you say that you didn't write the article. Well, the fact that I believe that the contents of that article is true, and no one is telling me that you didn't write the article, then I succeed on the claim because I'm not talking about you as a person. I'm not saying that you are that you're not I'm not talking about you as a person, and I'm not talking about your profession. I'm not I didn't do that. I just said I don't think that you would be the right supervisor for me because of your views of the transatlantic slave trade. That does not mean that I think that you are not a good professor. I think you're an excellent professor. And I think that you do phenomenal work with transitional justice. And I think that you are, from what I hear around the university, that you're a phenomenal person. But I just wouldn't want you as a supervisor over my dissertation. And I have the right not to want you as a supervisor over my dissertation. That's just my honest comment, an honest opinion. And there you have it, ladies and gentlemen. Don't forget to like, share, and subscribe to this video. Remember, your likes and shares, what it does is it pushes this video up in the algorithm. It tells the algorithm that these videos are important. Remember that this video is in the public's interest. There should not be speech that is being censored on the campus. Students should be able to communicate with their heads of school and do so without so I submitted an email, and I thought that I was actually communicating to the head of school, and that we were going to work on this, and that they were going to give me guidance about selecting a supervisor, and that is being used against me. And that does is it chills speech, and it prevents students from being able to reach out to their heads of school for support. And if you agree, ladies and gentlemen, I am going to be speaking about this on campus, and I will be asking for the opinions of students on this particular issue. Again, I really want to work this issue out with Dr. Luke Moffett. To reiterate, I've never met him, never seen him before, and I would be interested to know if he did write that article. But again, it's published on the QUB website, and I'm being called into the office, and specifically, the head of school cited the article. So that leads me to believe that Dr. Luke Moffett did write the article, and I just feel uncomfortable with the contents of it. And there you have it, ladies and gentlemen. Talk to you next time. Bye bye.